Hello, everyone. I just want to welcome all of you to the 2010 Fulton Lectureship in Legal History. The Fulton Lecture began in 1987 and is made possible by a gift from Maurice and Muriel Fulton, who are sitting right up there, both of whom attended the college, and Maury attended the law school, graduating in the great class of 1942. So it's really an honor to have you both here. We always schedule the Fulton Lecture so you can be part of it, and because it means a great deal to the school and reflects our commitment as well as your commitment to the field of legal history. Through the Fulton Lecture, over the years, we've been able to bring to the law school experts in legal history. And I'm also delighted to welcome, as this year's Fulton Lecturer, Sarah Barringer Gordon. Sally Gordon, as she's known to everybody who knows her, I don't know if I've ever heard you referred to as Sarah, is the Arlin M. Adams Professor of Constitutional Law and Professor of History at the University of Pennsylvania Law School. Sally's new book is entitled, it was actually just published at Harvard University Press, and it's called The Spirit of the Law, Religious Voices, and the Constitution in Modern America. And I was going to tell you a little bit about the book, but Sally and I talked beforehand, and that's what she's going to talk about, so I'm not going to tell you the punchline, so I'm going to let her do it for you. She has in her first book, The Mormon Question, Polygamy and Constitutional Conflict in 19th Century America, was published by the University of North Carolina Press in 2002 and has won multiple prizes. And she's now working on yet another book called Convictions, Mormon Polygamy, and Criminal Law Enforcement in 19th Century Utah. And you're working with Catherine Daines, and it examines the controversial history of polygamy prosecutions in the Utah Territory. Now, I'm always really excited and delighted to introduce people who come into lectures at the law school. That's one of the best parts of this job. Gives me special happiness to introduce Sally, because Sally and I were both colleagues on the same faculty. Way back, we were reminiscing about this a long time ago, but we both have convinced each other we still look young. But in any event, Sally was hired actually to the University of Pennsylvania faculty about the same time that I left, and I can assure you it wasn't a cause and effect. I remember when Sally came to the law school talking about polygamy, Mormonism, abolition. We all said, "My God, this person is a rising star," and I'm really delighted that you've risen and that you're now with us today. So, Sally Gordon.
Well, what a pleasure to be here. I thank my old friend Mike Schell, who I think was my colleague for about 20 minutes. Honestly, we missed him so badly. I thank the Fultons, and I thank also old friends and new who have come here today. I'm terrifically honored to have a chance to talk about this book project, which has been motivated by my desire to think through the ways that religious people and religious institutions have encountered the legal system and vice versa. And it's really the mutuality of that encounter that has fascinated me and that I believe has been vitally important to the development of constitutional law, but has not been widely studied. Scholars in church and state, as the field is widely called in the legal academy, have written very thoughtful analyses of legal development. The problem, from my perspective, is that the real story isn't just about law, it's also about religion. And so as I see it, we've heard about half the stuff we need to know because lawyers have so dominated the field. And their research has focused on law and legal change rather than the ways that religious and legal systems have become mutually engaged and have created a whole new terrain in constitutional law. So I wanted to get a richer picture of this relationship, and that explains my title, The Spirit of the Law. Lawyers use this term to mean the animating principles behind a legal rule or doctrine. They contrast the spirit of the law with the letter of the law. The spirit is the fundamental goal of justice and fair dealing, and the letter is what the law actually says. What many lawyers don't realize is that the phrase itself is biblical in origin. Paul's second letter to the Corinthians in the New Testament exhorts Christians to beware the letter of the law. And here I'm quoting, "For the written law condemns to death, but the Spirit gives life." The prophet Jeremiah spoke of the law written on the heart that forged a people of God. And it's this covenant that is binding Spirit-filled law in the eyes of God's peoples. In this sense, the Spirit reminds listeners of forces that lie outside secular law. And to those who speak in that voice, lawyers are the lay population. To those committed to secular law, those who are motivated by spiritual concerns are the lay actors, because they draw on non-legal experience and sovereign loyalties that lie outside the state. Yet our national Constitution commands those who enforce the secular law to protect and honor those who live by the Spirit. And here I'm talking about the first two clauses of the First Amendment to the United States Constitution, which says, "Congress shall enact no law respecting an establishment of religion or prohibiting the free exercise thereof." The letter of the law in America incorporates something of the Spirit. And believers have invoked the Constitution as a shield and a sword. This mutual investment in the spirit of the law has bedeviled those who have tried to put the ideal into practice. But the fact that they haven't agreed testifies to the difficulty of the enterprise, as well as their commitment to try to live out the Constitution's commands. I wanted to explore how believers came to court, what they found when they got there, and how the law of religion has affected religious life in America. I should stress that I am an historian, and I believe that to appreciate this relationship, one must see patterns that emerge over time and across religious and legal boundaries. In the end, I think I've found new ways to evaluate how we came to a place where fundamental disagreements about the Constitution have led to recriminations against the federal courts as hostile to religion. Tracing the roots of this charge led me to a new sense of the evolution of legal as well as religious doctrine. And I took a number of unexpected journeys, including finding that the Jehovah's Witnesses and the Nation of Islam share central religious doctrines and legal practices in common, exemplifying the ways that I found among multiple groups, ideas and practices travel across religious boundaries that might otherwise seem impermeable. I'll focus the rest of this talk on the way that religious actors contributed to the concept of separation of church and state on the one hand, and secularism on the other. But first, if this works, yes, I did it. But first, let me set the scene by telling you why the topic of my book is the past 70 years and why that period is different from prior eras. As I've pieced together the history, there are three great periods in religion and law. The first lasted approximately from 1770 to 1840 and involved widespread resistance to Anglican domination. Disestablishment was complete by the end of the period, and as I've learned recently, it was often accompanied by property confiscation at significant levels. The period included the drafting and ratification of the religion clauses, but also very quick agreement among experts that the clauses applied only to the federal government. At the same time, the period was marked by religious growth and great innovation, increased participation in religious life, and the beginnings of a politics of religion. The end of the period saw broad governmental agreement on acknowledgement and support for religion, including blasphemy prosecution, religious oaths, Sabbath legislation, and more. Supreme Court Justice Joseph Story said that disestablishment meant eliminating competition for government support among religious groups rather than terminating respect for and reliance on religion. But that respect and reliance must not be sectarian, he said. That is, it could not be associated with a particular religious denomination or religious institution. The second period lasted a full 100 years, from about 1840 or so to 1940. It was characterized by state control of religion, increasing political importance for religion, especially with abolition, prohibition, the social gospel, and so on. Religious groups in this period began the practice of voting by blocks, and they also contributed to great increase in wealth and property owned by religious organizations, as well as the gradual, and toward the end of the period, gradual appearance of interfaith goodwill institutions and a partial acceptance of religious pluralism. The third period, my period, began in 1940, when state control was abruptly undermined by the Supreme Court and matched by an increasingly powerful and invasive national government. The Supreme Court's decision to apply the Free Exercise Clause to the states came in 1940. But today I'll focus first on the Establishment Clause, which has long been the most divisive of the two. My story begins with the Supreme Court's incorporation of the Establishment Clause. By the close of the World War II era, the Supreme Court had folded key elements of the Bill of Rights into national law. And after the Free Exercise Clause was incorporated in 1940, it really was just a matter of time before the Establishment Clause was also pulled in. The event happened in 1947 in a case called Everson versus Board of Education of Ewing Township, a case that involved corrupt politicians and a totally bankrupt state court decision below. It was from, of course, New Jersey, the state of my birth. The majority opinion in Everson by Justice Hugo Black provoked 4 outraged dissents. But all the justices agreed that it was time to incorporate the Establishment Clause. The division was over the result. Was it constitutional to pay for bus transportations for students who attended private as well as public schools? All the students in the case attended Catholic schools, and the dissenters argued that paying parents to send their children for Catholic education was the same as funneling money to the church itself. Nonsense, said the majority. The safety of school children was key. Transportation provided for equal treatment of all children, no matter what their religious affiliation or where they went to school. The controversy at the court reflected debates going on around the country after World War II. As the federal government began gathering up steam to fund education nationally for the first time, Catholic leaders argued that funding must not leave out what they called the nation's alternative school system, parochial schools. After the Supreme Court got involved, long-standing spats between Catholics and Protestants had new fuel. The stage was set for what would become such a nightmare for the federal courts: endless debates about providing secular benefits to all children while at the same time avoiding support for religious education. Now, the Supreme Court's new regime depended on figuring out the difference between religion and everything else. The justices called a new constitutional environment into being a new world of religion and law, but they didn't do more than announce its existence, leaving it for future cases to fill in the world. And this is where it gets interesting. Long-standing structures and commitments from the old regime, the 1840 to 1940 period, where state law had ruled and where Justice Story, rather than, say, Thomas Jefferson, best described the commitment to separation of church and state, those structures didn't just disappear. Instead, they migrated into the new regime, pulled in by actors who understood the old world, but who found themselves horrified or entranced by the appearance of a powerful new audience in federal courts. Catholic-Protestant tensions flared. The story itself is both dramatic in legal terms, but also much more connected to American religious life and practice than we've appreciated. So let me get into the details. Catholic leaders were thrilled by the result in the Everson case. In one fell swoop, it became constitutional around the country to provide free transportation for parochial school students. But there was still plenty for them to worry about. For one thing, an influential group of Protestants claimed that the Supreme Court had betrayed the Constitution. By allowing a benefit to flow to sectarian education, they said, the court had breached the mandate for separation of church and state. 4 Supreme Court justices agreed with them. These religious leaders were so upset that in 1948 they formed a new organization with the goal of overturning the Everson decision. They called themselves, it's a really awkward name, Protestants and Other Americans United for Separation of Church and State. If you'll forgive me, I'll call them POAU. It is an organization that is still in existence, but now goes by the name Americans United for Separation of Church and State. You may have heard of it. When they formed, they wrote something they called a manifesto announcing their existence, and the full text of the manifesto was published in the New York Times. I have to say, this was not a secular organization. It was a decidedly Protestant endeavor, as the name indicates, and it was dedicated to rooting out sectarianism, convenient shorthand in many POAU publications and legal arguments. Sectarianism meant Catholic influence and teachings. And it turned out there was a lot of work for POAU to do. The organization became popular and successful. The ACLU has never had more than a small portion of the membership or budget of POAU at its height. And the American Jewish Congress remained on the sidelines of most of these disputes, especially in the early decades. POAU was the primary mover in cases that drew the line between public and sectarian education. After Everson, the next decade and more, from the late 1940s through the early 1960s, were consumed by this line drawing. POAU led an extensive campaign. They set out to rid the country of what they called captive schools, a label they invented to describe hundreds of public primary and secondary schools around the country. The story is almost completely unknown, in part because lawyers, well, honestly, they're glued to computer research and good online archives for newspapers and such. And scholars of religion who should know better have overlooked almost entirely the real effects of legal change on religious life. So this is one of those untapped gold mines, and honestly, I wish I could take credit, but it's not that hard to find. The papers of this organization are right at Princeton, and the minute you begin to dip into them, you find these controversies. We remember Everson, we lawyers remember Everson because it incorporated the Establishment Clause. But on the ground, Everson actually transformed educational practice around the country. In captive school cases, veterans of the old constitution, that pre-1940 constitutional world, fought over how to distinguish religious from secular education in the new era. Their battles reveal confusion about how to deliver an education and how to ensure that all children received one. Much of the work of disestablishment in these early decades was in disentangling religious or sectarian schools from secular or non-sectarian ones. Once you had figured out which belonged in which category, then you could start fighting about money. But first you had to do that sorting. This is the way it worked. In case after case, POAU charged that the public schools, I'm not talking about parochial schools, I'm talking about public schools, had been captured by the Catholic Church. And you see the sort of domination by religious symbols of the little helpless public school building. And actually, they were on to something. From the 1920s to the 1940s, municipalities around the country used parochial schools as sites of public education. Catholic parish and diocesan records, newspaper reports, and of course POAU's own materials make it clear that many school districts had responded to mandates for public education by relying on local parochial schools. In some areas, there never had been a distinction between Catholic schools and public education. POAU said all of these were captive schools and they must be cleansed of sectarian influence. It was an enormously successful formula. Within its first year, 600 churches had signed up to provide financial support. POAU leaders and activities were featured prominently in Protestant magazines and church newsletters. The organization urged interested people to contact them with complaints about Catholic influence, and by the early 1950s they had received, and thanks to them, saved many hundreds of these complaints. Two examples give the flavor of captive school controversies. The first comes from New Mexico and involved a resident of Dixon, New Mexico, Lydia Zellers, who was represented by POAU in a lawsuit against the local school. The trial court found that in many schools, and here I'm quoting them, there is no separation between the Roman Catholic Church and the state of New Mexico. In Dixon, the same school was carried on state records as a public school and on diocesan records as a parochial school. Here's a, can you see, get a bit of a sense of what's going on there. The teachers were all Sisters of the Order of St. Francis. Students attended Mass each week, learned Catholic morals, and were taught, as you see, by women in full habit. The school itself was decorated with crosses and statues of the saints. Many other states also mixed religious and public education. I found records from Kentucky, Ohio, Illinois, Indiana, Michigan, Missouri, Iowa, Texas, and more. POAU publicized and often litigated instances of capture in these places. Many other controversies evidently flew underneath the radar. The first time I presented a very early work on this research, a senior law professor came up to me and said, I remember the day in the mid-1950s when we were all told that the crosses had to be taken down from the walls of our school. There was no formal lawsuit. I can't find any record in POAU archives, but the school was called St. Elmo's, and it was changed from that day forward. I'm convinced that we'll never know the precise contours of the relationship between St. Elmo's Public School and local Catholic authorities, but there were a wide variety of different arrangements. In 1848, just to give you some sense that people on the other side of POAU also agreed, an internal survey conducted by a Catholic organization found what they called at least 324 parochial public schools nationwide and thought that there were many more. A second example shows one of the other ways that such arrangements were dismantled. In 1952, POAU representatives appeared in St. Bernard, Ohio, just outside Cincinnati, saying that they were responding, and I did find the complaint from a local resident. For more than 20 years, they said, the diocesan bishop had been raiding the public treasury. In fact, the school district had contracted out responsibility to the bishop to run the local public schools. Church buildings were rented for a nominal fee, often $1, $10 a year, and all salaries for teachers were paid directly to the diocese. POAU threatened to sue unless the bishop abandoned the contract, and even after the bishop assured the group that he would terminate it immediately, POAU refused to leave town until the contract had actually been abandoned and the bishop had thrown his weight behind support for building a new public school, this time not on church property. In these cases, POAU highlighted the ways that public education was imbued with sectarian influences. And around the country, hundreds of local public schools gradually cut long-standing cords of connection to Catholic educators. And POAU prospered. By 1960, it had more than 100,000 individual members, and more than 1,000 churches contributed funds. And even though they'd already had a profound effect on education, they claimed there was need for more. They conducted their own survey. You can't find any of the records they used to draw it up, so I have no idea what they really based it on. But they said they found hundreds more captive schools still operating in 22 states and 2,000 habited nuns and priests on public payrolls. They followed this up with a remarkable film called Captured. It's sort of a mockumentary almost. It's amazing, dramatizing the effect of a sectarian education on innocent school children. Now, as you must have realized, POAU had an anti-Catholic agenda. You think? Purging public schools of sectarianism was their primary goal, but they were also dedicated opponents of secularism. They were deeply motivated by a traditional Protestant vision of separation of church and state. That is, they opposed sectarianism, but they defended themselves vigorously against the charge that they promoted secularism by doing that. Instead, they relied on an older vision of the Establishment Clause, where non-sectarian religious practices in schools was not only acceptable, it was praiseworthy. That kind of religion in school was a defense against materialism and communism and juvenile delinquency, and wait for it, Jeff, premarital sex, drugs, rock and roll, right? We get the picture. But in the end, POAU was so effective at purging some kind of religion from public schools that the remaining kinds stood out. These practices were backlit by a focus on categorizing some practices as unacceptably sectarian and others as non-sectarian but thus allowed. As time went on, the elephant in the room became undeniable. The Supreme Court held first in 1962 and then in a second round of cases in 1963 that school prayer and Bible reading violated the Establishment Clause. According to these opinions, even non-sectarian religious activity could no longer be part of public education. POAU was stunned. They hadn't expected this, even though in retrospect they should have. By the early 1960s, prayer and Bible reading had long been controversial, opposed loudly by Catholics, dreaded quietly by Jews, and even criticized by some Protestants, especially Baptists, who embraced radical separatism. But most Protestants and most supporters of POAU were horrified at the ban on prayer in schools. They wrote angry letters urging POAU to fight the decisions. As one leader put it, we're damned if we do and damned if we don't support the ban. And truly they were caught. 80% of the population opposed the outcome, including 2 former presidents. The Supreme Court received more hate mail after this decision than at any prior time in its history, and impeach Earl Warren signs went up around the country. POAU had never thought of ecumenical prayer as a problem. But the new constitutional world revealed that non-sectarianism just didn't get the job done. If religious practices in public schools violated the Establishment Clause, then Protestant as well as Catholic exercises must go. After a great deal of internal debate, POAU cast its lot with supporters of the ban on prayer. But Protestant allegiance to school prayer ran deep, really deep. Many staunch Protestants had first become involved in constitutional law to defend public education against a perceived Catholic onslaught. And that made the Catholic response to the prayer decisions almost as devastating to POAU as the decisions themselves. This time, the Catholics changed their position and condemned the ban on prayer for introducing atheism and even communism into public education. Orthodox Jews joined the Catholics. Supporters of the ban were far fewer. The Congregationalists, the Unitarians, a few Baptists, liberal Jews, atheists, and a good sprinkling of agnostics. And of course, POAU, very lonely, found itself choosing secularism over religion in the new Great Divide. The divisions were long-lasting, and 2 major changes in religious life flowed from this fissure. First, the smaller one. POAU shrank and faded. Its support of the decisions flowed into a broader split within Protestantism, this one created by rival constitutional visions. Gradually, POAU found itself agreeing with a more secularist law of religion. Fellow travelers included civil libertarians and liberal Jewish groups and a few mainline Protestants. But these liberal Protestants haven't fared so well over the last 50 years. They have lost members and learned what it's like to be forgotten. Conservative Protestants have been more resilient, providing the second major example of change in religious life. Many conservative Protestants resisted the school prayer decision, condemning secularism and all its trappings. In the 1960s and 70s, pulpits rang with calls denouncing secularism and calling for the return of morality to public education. Ancient supports for separation of church and state gave way under the weight of secularism. The Southern Baptist Convention illustrates the enormity of the change. Southern Baptists had been vital to the founding and the early work of POAU, but only 15 years after the school prayer decisions, the Southern Baptist Convention was rocked by a conservative takeover that revolutionized their approach to law and politics. In the early 1980s, the SBC became the first major denomination to endorse a school prayer amendment to the Constitution. As one delegate put it, the atheists, humanists, and secularists are against prayer in schools, and that's not the company we need to be keeping. The battle against secularism reemerged in the 1980s from unexpected quarters. These folks had been POAU supporters 25 years earlier. Now they were dedicated foes. A key figure in the takeover at the convention was Tim LaHaye, most famous today for writing the Left Behind apocalyptic novels. He was one of 5 founding members of the moral majority in 1980. His wife, Beverly LaHaye, also became a national figure, not only in politics, but especially in law. She brought the battle against secularism back to the courts, working within an updated and retooled set of arguments. She founded Concerned Women for America in 1979, arguing that the family was under attack by secularists and that only church women had the strength and vision to do something about it. Her new organization was based on what she called biblical principles: family values, sanctity of life, parents' rights, and patriotism. By the early 1980s, it was the largest women's political organization in the country. By the mid-1980s, it claimed more than 500,000 members. But nobody studies LaHaye or CWA. That's because their archives are really hard to find. The organization has a closet in its lobbying offices in Washington, and you gotta go there. Just to give you a sense of how important this organization was, and it's still the largest political organization, women's political organization in the country. Phyllis Schlafly, who gets all the press, at its height, her Eagle Forum had 80,000 members. CWA was twice as big as the National Organization for Women. LaHaye also did something Schlafly didn't do. She litigated. CWA brought cases that are still well known to lawyers and academics in church and state. But more important to her core beliefs was a group of lawsuits that tested the boundaries between what is religious and what is secular, revealing how unformed the law really was. LaHaye translated the long-standing condemnation of secularism into a new argument that public education was contaminated by religion. She borrowed elements of older POAU arguments, but also inserted new claims. Like POAU, she claimed that public education was the target of a religious conspiracy. This time, the conspirators weren't Catholics, but secular humanists. Drawing on the work of her husband, Tim, LaHaye maintained that humanists had infiltrated key government organizations. He draws great graphs for us, including federal courts and public schools, and that humanists also dominated important private interests, such as media, the National Education Association, and, of course, the ACLU. LaHaye urged CWA members to contact her with complaints about secular humanist invasions, especially in schools. Young mothers complied and produced a series of cases that reflected the growing dismay of evangelical conservatives and the exasperation of school officials. Vicki Frost's case was especially poignant. Here she is. LaHaye held a news conference in Greenville, Tennessee in 1983 to announce that CWA was filing suit on behalf of Frost, her children, and other Christian families. The case, it may be familiar to some people here, it's known as Mozart against Hawkins County Public Schools, but everyone knew it was Frost's case. She was the first complainant and the star witness. She was also the punching bag for opponents who made fun of her rudimentary education. Her 4 children had been required to read new textbooks in school that she said violated her religious beliefs. She said the books taught not only, and here I am quoting from her, occult practice, but also about reincarnation, gun control, situation ethics, one world government, evolution, and pacifism. Their teachers had agreed to allow the Frost children to read an alternative textbook, but the school board voted unanimously to require all students to use the same textbook. Frost was even arrested and briefly jailed when she confronted the principal and shouted at him. Several students, including 2 of Frost's children, were suspended for refusing to read the books. Concerned Women for America said that Frost was right to object because these books were just humanist manifestos in not-so-subtle disguise. LaHaye argued that the free exercise must protect innocent children against insults to their religion. By translating secularism into a religious system, CWA could argue that Frost and her children were subject to a public education that was imbued with religion. This argument built on prior case law and exposed its vulnerabilities. The Supreme Court had restricted public school curricula to secular topics and placed religious instruction in an unconstitutional and prohibited category. So there's a great deal that had gone on. But the legal system had never defined religion. And every lawyer knows that if courts hadn't defined what religion is, then they couldn't conclusively say where it began and where it ended. Vicki Frost and Beverly LaHaye believed that those who had taken charge of public education were dedicated foes of Christianity. Really, they said, secularists were anti-Christian zealots who forced all children to read books that endangered their souls and intimidated their families. As LaHaye put it, the secularists' intolerance of religion was a dead giveaway for their plan to undermine the freedoms of all Americans. She turned to the Free Exercise Clause to protect Frost. In one sense, LaHaye's reliance on the Constitution reflected the resilient faith of these people in the Constitution and the rights of believers. That popular faith survived even when it was clear that technical law had decided against them. In LaHaye's case, the claim that secular humanism was in fact a veiled religion exploited the gap in the law of the religion clauses and turned the tools of the federal courts against themselves. In politics and broader society, I have to be said, the claim that secular humanism is actually a religion didn't gain much traction. One critic said, oh, it's just a heuristic device. But in law, the concept had a rich and interesting life. In the Frost litigation, the inversion of what traditionally counted as secular and what was religious drew attention from scholars, reporters, activists around the country. Everyone watched the case. After many painful hours on the stand, the shy, timid Vicki Frost was vindicated. The trial judge held she and her fellow plaintiffs could instruct their children at home using texts that had been previously approved by public schools and then have them tested in school for analytical skills and so on. LaHaye was thrilled. She claimed victory on behalf of Christians around the country, and she drew substantial support from some surprising quarters, including Nadine Strawson, the future president of the ACLU, who warned her fellow civil libertarians against denying the right of some children to opt out of school events on religious grounds. But most of the left lined up against LaHaye and Frost, and the left won in the end. The Sixth Circuit held that because the ideas in the required case books, naturalism, moral relativism, diversity of beliefs, and so on, those ideas weren't truly religious, they said, and so the forced participation of students wasn't really a burden. Instead, the students should accept that the texts encourage tolerance and respect for true diversity. In the end, LaHaye gave up, and the argument that secular humanism is a religion has sputtered. But religion still has no coherent definition in constitutional law, and LaHaye's work exposed the fact that courts in this hotly contested area are working without consistent categories. Yet they deny litigants the power to claim that their own religious convictions should determine their right to find alternatives to offensive materials in schools. In this story, connecting POAU's captive school cases to LaHaye's campaign, you will have noticed that religious conspiracy plays a certain role. And in some sense, there is a kind of classic paranoid style. But I want us to push beyond that, because religious conspiracies are peculiarly believable in the era era, right? In a new substitute for political conspiracies. See not only these novel and nonfiction books, but popular TV show, Lost, any number of thrillers, and so on. More important even than this, though, is the way that believers mobilize to protect and nurture their own visions of faith and the Constitution. And as POAU shows, separation of church and state was decidedly not the same thing for most of the 20th century, and even after it became identified with separation of church and state, many people in the country fought back. And Concerned Women for America illustrates the vulnerability of secularism as the purported opposite of religion, changing meanings of what secularism is and what sectarianism is, and the ways these were fought out in public education has made enormous differences, both to legal outcomes and to religious life. So what's the takeaway? And here I promise you I'm summing up. Obviously, I think that there's a much deeper relationship than we've appreciated between belief and law. I've talked about secularism and sectarianism, but the field is ripe for work. Religion is now, according to the AHA, the #1 topic of interest for young historians. It's time for them to focus on the importance of law to the history they're studying, and also time for legal historians to begin taking religion as seriously as they do law. More important, has this encounter been productive? Well, it may be too soon to say. Certainly, Beverly LaHaye and POAU felt betrayed by the legal system. Many judges have also been dismayed by their inability to construct a lasting and elegant legal system to guide our interpretation of the religion clauses. So there's a lot of controversy and a lot of pain. But a remarkable silver lining came from Justice Sandra Day O'Connor in 2 of the least respected cases in recent Supreme Court history. On a single day in 2005, the court held that it was constitutional to display the 10 Commandments on the grounds of the Texas state capitol, but not in a Kentucky courthouse. Ugh, right, I mean, that really did not play well. O'Connor wrote separately, reflecting as a justice only a few weeks before her retirement from the court. She stressed that avoiding controversy should not be the court's goal. Instead, she argued for keeping the system we have. She urged her fellow justices to recognize the beauties of the law of religion in America. And here I'm quoting from her. "Why would we trade a system that has served us so well for one that has served others so poorly?" So, yes, there's a heavy dose, even, of American exceptionalism in this call. But her rhetorical question raises a follow-on one. How could she describe the law we've been talking about as a success? It's a mess. It's divisive. It's controversial. The sheer amount of energy poured into litigation on religious topics in the last 70 years. This is a good thing? Maybe. And this is what I think she was getting at. Before 1940, religious strife reliably occurred along denominational lines. Anti-Semitism, anti-Catholicism, predictably. The Supreme Court began generating controversy through its decisions right from the get-go. And it's fair to say that hate-filled talk and enmity are still common. But much of it is now directed against the Supreme Court. Cooperation along religious lines is common, far more common today than we could ever have imagined 70 years ago. Often, of course, cooperation is opportunistic, undertaken only to fight some heinous federal court ruling. Can you say National Day of Prayer or something like that, right? But the turn to law has become settled constitutional practice among religious groups. Now they argue about their place in society in explicitly constitutional terms. Jordan Lawrence, who is a veteran litigator for the Alliance Defense Fund, began his career at CWA working on Vicky Frost's case. He is still conservative. His new organization espouses many of the same values as CWA. But Lawrence wrote a friend of the court brief to support the ACLU in the Bong Hits for Jesus case, claiming that a high school student should be protected for holding up a cheeky sign at a school event. 20 years ago, liberals were so worried about allying with CWA that Nadine Strawson couldn't talk the National ACLU board into supporting Vicky Frost. The Bong Hits case suggests that the law of religion may have divided groups against their own, but it has also generated new and unlooked for strands of connection. If there's any merit to Justice O'Connor's claim that this constitutional terrain has produced religious tolerance, then it has great, maybe even inestimable value, even if we haven't figured out yet and don't see our way to doing so. We haven't figured out how to draw sensible or reliable boundaries around what is religious and what is secular. Thank you.
Sally has kindly agreed to take a few questions from the audience, so I will let her do that.
Thank you. Professor Epstein.
Yeah, it's a simple-minded question, but you did not mention, at least in my record, what was the book title, like Haiti and Vicky Frost case that prompted this kind of a situation? And the reason one wants to know is, you know, if it were the Hardy Boys or the Bobbsey Twins, it's one thing. And, you know, I can't quite figure out how to think about this case because I don't know what's on the other side.
Okay. The books were a brand new series by Holt, Reinhardt, and Winston. And the things that Frost objected to so strenuously included stories about witchcraft, stories that asked readers to imagine themselves on the moon or as a tree, stories about other religious faiths, and so on. The Tennessee statewide, Department of Education, I'm not sure I have the name precisely right, had approved 2 textbooks for schools in Tennessee in the 1982-83 school year, of which this was one, and Frost and LaHaye asked if they could use the other. It's not really such a stretch. I mean, they weren't asking for something that was out of the realm of reason in terms of education. But when a lawyer asked Vicky Frost, for example, why she objected to a story about imagination, she said, our children's imaginations must be bounded.
Why didn't the school accommodate?
The teachers wanted to. The teachers wanted to. The school board was infuriated, and there were many local pastors, for example, who stood up and said, I've read this stuff. I'm very sensitive to the presence of the devil. I don't feel Satan here. It really divided the town. And what happened was, so Concerned Women for America kind of rode in with a big evangelical machine, and on the other side was Tony Podesta's, minutes-old organization, People for the American Way, and they rode in on the other side, making it a really national story. They labeled the trial Scopes 2. Yeah.
What happened is the outsiders took it over and converted it into Gettysburg.
In some sense, although Vicky Frost is a well, she now has terrible agoraphobia. She still lives there. She's divorced. Things went very, very badly for her. She is part of a sizable minority within the community, and she really cared about this stuff. So she didn't make it up. But you're right that the headlines grabbed. It spiraled away from Greenville at a certain point. Professor Stone.
A comment about the exchange you said, Richard. It seems to me the reasons why the school board were not happy about the solution of accommodating her is that once you open that door, everybody can ask for accommodation.
Yeah.
Not only given the theory of the argument, not only everyone who has a religious objection, but everyone who has any objection.
Yeah, that's.
They're all religion according to them.
That's a great point.
About the Vietnam War, I can take my kids out and have them read their own books.
Yes.
If you take them seriously.
If you are a religious pacifist. Yes, indeed. I think this
You don't have to be religious pacifist, is my point. Once they say secular humanism is
I see.
then everything is religion.
Perhaps. One of the difficulties associated with this strand of litigation, and I thank you for your question because I couldn't squeeze in this bit, is that this was one of the last attempts of this enormous swath of people to stay in public schools. There was a heartbreaking concurrence from a brand new judge at the Sixth Circuit who said, the teachers want to do this, the kids want to do this, it's not costing us money, we should let them do this. And the reason I am not dissenting is that the Supreme Court has to decide this. It's a clarion call for the court to take the case. And in that sense, LaHaye and Concerned Women for America really fought, especially for a group of poorer conservative Christians, to be able to stay in the public schools. Honestly, those kids were getting a pretty good education in Greenville. I've been there. It's a very decent school system. The division, I think you're right that at the higher levels of the National Education Association, for example, the teachers in the school were fine with accommodation. The National Education Association wasn't. Sort of like the preachers in the town said, we have no problem with our children reading these books. And the fights came from that higher level, which is exactly what Professor Epstein was talking about. I do think this is really a last-ditch effort. The other lawyer who worked on Vicki Frost's case is a guy named Michael Farris, who went on to found the Homeschool Legal Defense Association and is now chancellor of Patrick Henry University. In that sense, you can see some optimism in bringing these cases. I was reading a case from the First Circuit. I guess it's about a decade old now. It's called the Hot, Sexy, Safer case. It's I got it in a, yeah. It's about a sex education film, and there were a group of parents who objected to the film, which I've seen and is explicit. And the First Circuit said, get out of here, no chance. And so I think the ability to object to school curricula at this point really is gone.
A follow-up question, why didn't Yoder resolve this?
What did Yoder resolve? That's such a great question. The amazing non-delivery of Wisconsin against Yoder. I think that, can you help me answer that question?
Get the kids out of the school system as opposed to letting them tell how the school system should be.
Yeah. Well, they were. They were going to read at home and have standardized tests at school. So the parents were doing it all. I think part of it is that the Amish were small, and the flood of claims that came after Wisconsin against Yoder really disturbed a lot of people. It was Douglas's partial dissent in that case that said Reynolds against United States is going to be overruled next, right? Polygamy's the next thing. I mean, litigants rushed to court, and Justice O'Connor, who said how beautiful the law is, was, you know, really good at smacking them down. She rarely met a free exercise case she really liked, or she only liked it in dissent. So I think that's a great question. I don't honestly deal with that. It has puzzled me for a long time why that was such a non-delivering case. I see a hand up back there. I'm sorry, I don't see who it is.
In the 60s, a very popular president, John F. Kennedy,
Yeah.
moved the country to accept the Catholic president. What was JFK and his Attorney General, Robert Kennedy's view to the POA movement?
Okay, that's a great question. Because, of course, Vatican II is also very, very important. And I don't think JFK got this job done. I don't think the Kennedys got this job done. I think Vatican II was hugely important. I think also one of the things that has reconciled, I guess is the right word, many Protestants to the existence, especially of the parochial school system, is its collapse. I know that it's really true. 1 out of every 3 parochial schools closed in a 3-year period from 1968 to 1971. That's huge. We're in another big round. Are you here in Chicago, in Philadelphia? We've got some beloved schools closing. A large part of it is the fall off in vocations among women. They're down to under 10% of what they used to be, and also the fall off is even more sharply observable in the number of women religious, cloistered or otherwise, who are willing to teach. So there's a huge, huge labor shortage and personnel shortage in this massive school system. And of course, when POAU began litigating, parochial schools were free, and now they charge. So it's really a very different, that it was a pre-Vatican II world, it was a pre-tuition world for Catholic schools, and yes, you're right, it was pre-Kennedy.
Time for one more question.
Yes, at the back.
Can you provide a little bit more detail on the connection between Everson and Protestants and other Americans United at the instigation? The reason why I ask, of course, is because Everson validates the program. I can imagine what the connection might be. For example, you shifting the venue for controversy from state courts to federal courts. Maybe that's it. Maybe it's because of the analysis, both historical and other, in the Everson decision that instigates. But I have some doubts, I guess, because it's so often true that the Supreme Court lands way behind state litigation, controversy elsewhere, for the time to reach these issues, and that suggests to me that there's probably the same sorts of complaints being made about this relationship between those two systems and Catholic institutions well before Everson itself.
That's a great series of questions. Let me see if I can begin with what Protestants found in Everson that got up their nose so badly. They didn't care about the historical analysis. What they cared about was the result. And it's remarkable, POAU never, you know how you think of, these brilliant legal minds working, I don't know, at the American Jewish Committee or the ACLU. I guess by 71 it had become Americans United. Was a loose cannon. And apparently these other organizations, sat on their briefs or their cases for a long time because they didn't want these folks getting involved because they were they weren't interested in building doctrine. They wanted to win, and they didn't care how they did it. So the historical analysis meant nothing to them. Busing kids to parochial schools meant everything. And yes, there was a lot of litigation. There had been Supreme Court decisions in 13 separate states by the time the Supreme Court took this busing decision. And what's remarkable to me is that they took, I mean, I can't tell you how bad it was in New Jersey. This was a bill sponsored by Frank Hague, who threatened to fire any employee who didn't give money to support the effort to pass the bill, and who owned the Supreme Court of the state of New Jersey, which held, I forget the exact number, it was 6-3 or 5-2, I forget. They held that, well, maybe the busing bill, it was called the parochial school busing bill to give you a sense of how explicit everything was here, maybe the money that pays for these Everson kids doesn't come from the state, right? Maybe it comes from local taxes, and therefore it's not a state problem. We don't really have to worry about it. And the dissenters said, you're crazy, right? You can't divide up the pie like that. The money's thrown into the school tax bucket and everybody gets some. And you can't trace it back. Like, it was a nutso opinion. So why the Supreme Court took this case rather than another one with its very messy background, I have to tell you, the opponents of the parochial school busing bill had some intimate relationship with the Klan. I mean, this was not a pretty lineup on either side. So yes, there's lots of state litigation, but this case, of all cases, I think was not particularly clear-cut or well litigated, and it didn't involve the issues in a sort of upstanding way. The last question you had was about state litigation, and I want to turn it in another way as well, which is that POAU always preferred to sue in state courts. They were founded, they said, we hate Everson and we're dedicated to overturning it. And for a long time, they expected one of their captive school cases to go up. They thought that was going to be the next big school case. But in the end, they found they did better. It was cheaper, quicker, and more politically salient to file in state courts, not federal courts. That's another reason the sort of fancier public interest organizations found they didn't like working with these guys.
Thank you very much.
Well, thank you.